My name is Eric Owens, and I'm the Associate Director at the Bwazzi Center for Religion and American Public Life. And it's my pleasure to welcome you here tonight to our penultimate event of the semester. I'd ask that before we get started, you turn off any sort of ringers or buzzers or anything like that you have on your person. And I'll try to do the same as well. I'd also like to mention that the university's video recording service, Front Row, is recording the event this evening, and that video will be posted on a streaming basis sometime when they get a chance to edit it, typically a couple weeks. But if your friends or colleagues weren't able to make it tonight, you can encourage them to visit our website, bc.edu/Bwazzi, and you'll find links to frontrow.bc.edu as well as all sorts of other information about our topic tonight. So I mentioned this is our penultimate event. Our final event of the semester is next Thursday, a panel entitled Humanitarian Intervention and the Responsibility to Protect, featuring Professor David Hollenbach from here at BC, Professor Mahmoud Mamdani from Columbia University, and Professor Alan Wolf, Director of the Bwazzi Center. And that'll be in Higgins 300 right behind you, the room behind us. All the details, of course, are on our website. But you're not here for that tonight, and you're here for something very special. Our topic for this evening, religious exemptions and the healthcare debate, might seem a bit cryptic for those unfamiliar with the sort of legal jargon. But the concept of an exemption can be put relatively simply. A religious or conscience-based exemption is a law, regulation, or judicial ruling that exempts someone from a rule or law that would otherwise apply to everyone, for reasons related to moral or religious conviction. At stake in the issue of exemptions, you might say, is a fundamental clash of values between religious liberty and equal treatment. Do religious people and institutions deserve special treatment or accommodation because they're religious? In the healthcare debate, these issues come to point for institutions as well as individuals. The institutional question has been front and center for the Catholic Church in particular, which operates a vast network of hospitals and other healthcare facilities that receive federal payments for medical care. Some Catholic Church leaders in this country fought the Senate version of healthcare reform legislation out of a fear that it might allow federal funding for abortion-related services. But there are a host of related issues that I'm sure Father Hehir will discuss for us this evening. On an individual level, concerns have been raised about the rights of pharmacists and physicians who refuse to be complicit with particular forms of care or counseling related to abortion or end-of-life questions. How should the healthcare system balance respect for personal conscience with the professional responsibility to provide care to all who need it? Now, rather than try to frame this conversation too tightly at the outset, I want to let our distinguished guests speak for themselves and from their own experience on these issues. And to speak in understatement, their experience is vast and impressive. So I'm pleased to introduce right now our panelists in the order in which they'll speak. Our first speaker, Father Bryan Hehir, is one of this country's most influential Catholic thinkers on both foreign and domestic policy. In addition to his priestly duties, he somehow holds two full-time jobs. One is the Parker Gilbert Montgomery Professor of the Practice of Religion and Public Life at Harvard's Kennedy School of Government. The other as Secretary for Healthcare and Social Services in the Archdiocese of Boston. In foreign affairs, Father Hehir is a scholar of political realism, nuclear weapons, and the role of religion and ethics in international politics. In domestic affairs, he has broad and deep experience in questions of religion, ethics, and social policy. His previous posts have included service as President and CEO of Catholic Charities USA, head of Harvard Divinity School, Professor of Ethics at Georgetown, and on the staff of the U.S. Catholic Conference of Bishops. He's a recipient of numerous honors, including a MacArthur Fellowship and honorary degrees from 25 institutions, perhaps more at this point. He holds a BA and MA degrees from St. John's Seminary in Boston and a THD from Harvard Divinity School. Second, we'll have Dr. Michael Greene, who also wears two hats. One is a professor of obstetrics, gynecology, and reproductive biology at Harvard Medical School, and the other is chief of obstetrics at Massachusetts General Hospital. Dr. Greene's major academic interests are in medical complications of pregnancy and congenital malformations. He served as associate editor of the New England Journal of Medicine since 1996 and has chaired the Committee on Obstetrical Practice for the American College of Obstetricians and Gynecologists. He's a consultant to the Federal Food and Drug Administration, where he served for 4 years, 2 as chair, on the Advisory Committee for Reproductive and Urological Drugs. In those capacities, he advised the FDA regarding the conditions for final approval of RU-486 and recommended changing the status of the prescription emergency contraceptive Plan B to over-the-counter. He's currently a member of the scientific advisory committees of the National Children's Study, conducted by the Eunice Kennedy Shriver National Institute of Child Health and Human Development, and the March of Dimes panel on preterm birth. His MD is from SUNY at New York City, and his residency from Boston Hospital for Women, and his fellowship was completed at Brigham and Women's Hospital. So welcome. And finally, we have Melissa Rogers. Of course, she too wears multiple professional hats. She's the director of the Center for Religion and Public Affairs at Wake Forest University School of Divinity, and a senior fellow in governance studies at the Brookings Institution in Washington. Before teaching at Wake Forest, she was executive director at the Pew Forum on Religion and Public Life in Washington, D.C., where we first met, which she built into an influential center for nonpartisan research and informed debate. Prior to that, she served as a general counsel for the Baptist Joint Committee on Religious Liberty, where she helped to shape the organization, urge greater legal protection for free exercise rights. In 2009, President Barack Obama named her to the Advisory Council of White House Office of Faith-Based and Neighborhood Partnerships, which grapples with, among other things, the question of religious exemptions in hiring practices. She's the co-author of a casebook on religion and law, and the lead author of a recent report, Religious Expression in American Public Life, a joint statement of current law. Her law degree is from the University of Pennsylvania. So as you can see, we have a terrifically distinguished panel of guests tonight. I've asked each panelist to take about 15 minutes for their opening remarks, and then we'll have the remainder of our time today for discussion with you. I'll also note that the microphones need to be turned on, a little switch behind up here. So you can do so when it's your time to speak, I guess. It's on now. So we'll begin with Father Hehir.
Thank you very much. I appreciate the opportunity to be back at the Boissy Center. Every time I come, it's an invigorating discussion about an insoluble problem. So my sense is that this will be my third time around, and the problem will be equally insoluble, and it'll still be great, and I'd be glad to come back a fourth time when you think up another one of these Rubik's Cubes that we should think about. I do come to this question from a combination of both what I teach and some of what I write about and what I do. As Eric said, I teach in the area of public policy and ethics, and particularly about religious questions as they affect public policy and ethics in the life of the Catholic Church. And I have had these experiences of directing national Catholic social service agencies like Catholic Charities. And here in the Archdiocese, there are 6 social service agencies that report through me to the Cardinal, and then I represent him to 2 Catholic hospital systems. So these kinds of questions are sort of with me all the time. I thought in 15 minutes what I might do is to try to answer 3 questions. Why now? Secondly, what role for conscience causes? And thirdly, how do we choose our future on this question? I begin with the question, why now? Why would there be a panel on religious exemptions / conscience causes? Eric has defined what we mean by religious exemptions or conscience causes. Essentially, to paraphrase a definition that is offered in the Hastings Center, a conscience cause is a standard of civil law which protects the right of a professional or an institution from performing a legal act because of either personal, moral, religious convictions. The question is not a new question in the United States, but I think the why now, the reason we're here, is that conscience causes have become acute, if you will. They have become a disputed element in principle, at least as I understand it. There are a range of public policy issues that are not only questions of religious exemption from public policy, but also moral exemption, not necessarily grounded in a religious conviction. You might ask the question, why now, in terms of how narrow the question seems to be at one level. We've just been through a major macro debate about healthcare reform as a whole, who gets healthcare, under what conditions, and that is a debate that took us to the heart of the American economy, to the question of the U.S.'s role in advanced industrial democracies. It cut across politics, economics, ethics, institutions, and individuals. other macro issues like stem cell debates and stem cell research and assisted suicide, these are large public policy questions that get discussed in terms of law, policy, and the major structural questions that affect a society like ours. The Conscience Clause question descends to the personal and the particular. So that's why I say, why now? Why not stay with the macro questions, or do the macro questions overwhelm these kinds of personal and particular questions? But I suggest it's really interesting to look at the intersection of the macro questions and the personal conscience questions. Let me simply revert for just a moment to the area that I spend more time on than I do on these questions, and that is military issues and the ethics of military strategy. The way those questions are discussed is in terms of grand strategy. If anything, they are broader than the questions we discuss in domestic policy. They're about life and death in terms of sovereignty, protection of the nation, dealing with terrorism, etc. So you usually discuss these questions at the grandest level, if you will, high politics, as it's often called. But then, in the midst of that, there is the soldier. In the midst of designing grand strategy, there is the pilot. And that end of the telescope, once again, becomes a question of conscience clauses, religious, moral exemptions, a sense of public duty, and how public duty is reconciled with the deepest personal convictions individuals hold. I think the fact that we combine the macro issues and the personal questions, whether it be in healthcare or military strategy, the fact that we do that expresses a concern in American law and policy for the life of the individual within the context of the wider society, particularly a concern in law and policy for the life of the individual under orders, under fire in military terms, under orders, under professional duty in medical terms. Always the question that public service is motivated by professional and personal commitments, and therefore it is important to be able to reconcile the broad, sweeping characteristics of the strategy you pursue as a nation in war or the law and policy that directs one's professional care for individuals in the bioethical area. Indeed, if you look at the evolution of this question in this country, the first approach to conscience clauses, I think, were precisely the claims of pacifists in this country, and at first they got very short shrift from the U.S. Supreme Court, the early appeals to exemption from war. But the 20th century has seen a remarkable growth and deepening of precisely a concern for the conscience of individuals. During Vietnam, the role of the individual in protesting a war, if he or she were opposed to it, produced the Hehir case, where you no longer had to claim that it was a religious exemption that motivated you, but in fact it could be a purely moral exemption or some functional equivalent to religion. During the 1980s, there was a remarkable descent to the particular, to the specific, almost to the tactical, in terms of protecting the conscience of individuals in the Air Force when the debate was about nuclear policy. There was, in fact, a change in the practice of the Air Force that if someone was going to be in a nuclear silo, it was no longer enough to say that they had signed a paper that said they would obey the commander-in-chief. If they were going into a nuclear silo, it was now necessary for them, in a sense, to make a second commitment that they did not have objection to this particular kind of duty. So my point is that the most studied and expansive area of conscience on this question in the military area is an interesting backdrop for thinking about this concern of the personal commitment in terms of the profession of the military, of the medical profession and bioethics. So why now? Why now is there more controversy about this question? Well, I think in one level it is to be expected that there is to be controversy. We live in perhaps the most complex religious, moral pluralism of any society in the world. It's arguable that India is more pluralistic, but in fact there are few societies in the world that have such a range of religious moral conviction. And the challenge of a pluralistic society, of course, is to protect the deepest religious and moral concerns of each citizen, and at the same time be able to make public policy in a way that is coherent and effective. So here comes the tension. How do you make public policy that is coherent, effective, efficient, responding to problems, and at the same time recognize that there are some public policies that will run counter to the deepest convictions of individuals. So I always think of the challenge of religious pluralism as in terms of space, coherence, and exemption. You have to provide the space for each individual to form his or her conscience and to be able to hold the position they have come to. At the same time, you can't have simply laissez-faire arguments about everything. There must be coherent public policy adopted either through legislation or through the courts. But then, once you've adopted the policy, it may be necessary, in order to protect space, to once again allow for exemption. So why now? Because of the kind of society we are. Secondly, why now? Because I think it is fair to argue that there are deep cultural, moral fragmentations in American society. James Q. Wilson, formerly of Harvard and now of Pepperdine, came to give the Tanner Lectures 2 years ago at Harvard, and his question was, is there polarization in the society? And he took up counter-arguments from people close to him on the political and moral spectrum, like George Will, who said polarization doesn't exist, it's only among the elites. Wilson argued that polarization was in fact a major concern in American society, and the second of the two Tanner Lectures said religion was the most polarizing force in the society. Now, that degree of cultural religious fragmentation is not universal. Looked upon historically, I think you could argue that we have more coherence and more unity on race today, certainly than you had in American society 40 years ago. But particularly in the area of bioethics and other questions affecting gender and family, there is a more contested public agenda today. So if you have a more contested public agenda based on moral and cultural arguments, then I think the question of how we frame public policy in the middle of that fragmentation and how we meet standards of coherence, democratic rule by law and the courts, and at the same time provide room for the individual is precisely the test question. To some degree, this is a jurisprudential question. The law is made, the moral argument is made against it, and then the political choices that follow from the law are made at the level of policy and regulation. And this contest of law, morality, political choice often must be mediated in part, I think, by protection for the individual conscience. There also needs to be other things like basic civility, attention to evidence in the arguments, making the argument on the basis of reason rather than innuendo and ad hominem. So I think the kind of society we are in terms of religious moral pluralism, the kind of cultural and moral fissures that we deal with, at least in some areas today, and the attempt to bring some kind of coherence here in the jurisprudential conflict. All of that, I think, is part and parcel of why this issue is important. The Hastings Center, in one of its essays, said conscience causes could not be looked at simply as personal questions of individual rights because they have social import. My response to that is that's true. They can't be looked upon only in terms of individual rights, on either side of this equation. but they can't be looked upon as less than individual rights being protected. At the same time, it is a social question because these issues affect institutions as well as individuals. So what kind of role does conscience clauses play for individuals and institutions? In a sense, I think what they seek to do, to borrow a term that is obviously much part of bioethical debate, they seek to protect personal and professional autonomy. Now, personal and professional autonomy being protected by conscience clauses will impact the personal autonomy of others. So it is important to say that from the outset. You don't have a problem if you eliminate either side of this equation. I do think that in the United States, the particular role of religious conviction as protected in the First Amendment is going to mean that this question is bound to come up. So going back to Eric's point, I think it's a pervasive kind of question that is rooted in the particular role that religion is given in our constitutional system. It is also important, I think, to recognize that to some degree the institutional level of this question arises out of the very fabric of American social policy. I think if you look at the advanced industrial democracies of the world and look at the arena of social policy, the United States could be characterized this way. We expect less of the state, more of the market, and a lot from nonprofits. And among those nonprofits, religiously based nonprofits play a major kind of role, precisely because our conception of the welfare state is much narrower than Europe, precisely because we depend on the market for so many things. Think of welfare reform, think of the healthcare debate. There is bound to be a large gap between what we get from the market and the state and what's necessary. This is where religious nonprofits fit in. As Eric indicated, the Catholic Church by definition gets touched by this precisely because if you have 600 hospitals, 175 Catholic Charities chapters around the country, you are going to run up against these kinds of tensions as you try to provide a public service, but don't always live under laws that you necessarily agree with. My sense is that in terms of choosing our future on this question, we need to ask the question, what could be lost if we can't find a fair adjudication of this issue? The issue by definition is shot through with tension. If you think of the conscience clause protecting the professional, then you have to think about access to service on the part of clients of various kinds, patients or clients in social service agency. So there's inevitably going to be a balancing in the resolution of this question. What could be lost if we don't do this well? My sense is what could be lost on the one hand is a damage to the professions involved. What also could be lost would be this characteristic of the social system where it is pervaded by nonprofits, almost in a de Tocquevillian way of using a pluralism of actors in the system. My general sense is that unless we choose well on this, we could harm the profession, the social system, and clearly if we don't choose well, we could harm the individual who needs precisely the services. So to conclude, my basic position is that conscience clauses provide an essential political legal component to adjudicate deeply held positions and convictions in this pluralistic society. I think the resolution of the issue requires defining the issues broadly. Pay attention to all the actors, their beliefs, their interests, and the duties involved, and recognize that conscience clauses will limit the rights of others to some degree. So then the question becomes, how do you deal with that tension and limitation? I think conscience clauses should be claimed only for essential issues, not capaciously, if you will. And I think, on the other hand, those who find conscience clauses difficult to accept ought to ask the question about what happens if the very idea of conscience clauses is eroded. And the effect of that outcome could well be that you use the power of the law to drive a wedge between professionals' deepest convictions on the one hand and their ability to provide effective public service on the other.
Thank you. Thank you very much, Father Hehir. We'll move on directly to Dr. Greene.
Well, I too would like to thank you very much for inviting me this afternoon. I must say that I thought when I received your email that the notion that you would attract a full room at this hour for this subject was wildly optimistic, but I'm quite impressed, and thank you very much. And I'd also like to congratulate you on the victory in hockey the other night for the Boston College team. And finally, I have one disclosure to make, and that is that my daughter is a Hoya. Using Dr. Hehir's analogy, I'd like to just make it very clear that in this debate and in this discussion, I'm very much a foot soldier in medicine. I practice medicine every day, and that is the perspective from which I make my comments this evening. I thought it would be helpful if we just talked about medicine specifically, since that's my game, and a few sort of ground rules and specifications. It's helpful sometimes to remind ourselves of what the goals of medicine are, and they're not always clear, and it's helpful sometimes to have a statement, and there are as many statements of the goals of medical care and medicine as there are people who have propounded them, but a reasonable one is the prevention of disease and injury, the relief of pain and suffering, care for the chronically ill and dying, and avoidance of premature death. That's a reasonable synopsis in the broadest possible sense of the goals of medicine, and that would be true for modern medicine as it's largely been through time. There's nothing natural about what we do. In fairness, one of the biographers of Charles Darwin, George Gaylord Simpson, who was himself a student of evolution, once said very famously that if evolution had a court, all physicians would be in prison. So what we do is not natural. We, in many ways, fight nature. But in so doing, all of our actions must be guided by several principles, ethical and moral principles that we all accept in our profession. First is respect for the autonomy of the individual. And as Father Hehir alluded to, respect for the autonomy of the individual is central to everything we do. What does that mean? Does that mean that a patient has the right to request anything of a physician, and that physician has the responsibility to do it without discussion or without reservation? No, it doesn't mean that. And we have to be very careful about distinguishing between a patient's right to request a treatment and their right to refuse a treatment. So if a patient comes to me and says, I'm very concerned, I was just reading about ovarian cancer, I would like both of my ovaries removed. I'm worried I might get ovarian cancer someday. I have a responsibility to explore where that request comes from and to bring some rationality to it. Does she have family members who have ovarian cancer, et cetera, before I would proceed, okay? The next is that patients have what we consider to be an unassailable and inviolate right to refuse care. So that while a patient can't request any care, she I'm always dealing with she, can refuse care, okay? And sometimes this puts us in a very difficult position. And here I will tell you of an anecdote that is a true story. Some years ago, I was caring for a young woman who had an unplanned and, in fairness, most likely undesired pregnancy. She came to our labor floor in labor. We examined her, we evaluated her fetus, and it was obvious that the fetus was in severe distress, and that if we didn't perform an immediate cesarean section, that fetus was going to die. We tried very hard to persuade this woman to permit us to perform a cesarean section, a mainstream, well-accepted procedure in medicine. She refused. That didn't mean that we had an obligation to say, okay, and walk away. We had an obligation to do our best to convince her that her decision was harmful, was inappropriate, and was wrong. We have, because we have respect for a patient's autonomy, doesn't mean we don't have our own opinions, and doesn't mean that we don't have an obligation to try to convince a patient that what we think is in her best interest, ultimately, is truly in her best interest, okay? She ultimately refused, and we stood by, and in fact, we unfortunately watched her fetus die. These kinds of things do occasionally happen. They're very, very rare. But it's one of the more painful things that we sometimes have to do as physicians, and speaks to the conflict sometimes that we can get into between our conscience, if you will, and the patient's right to make her own decisions in her own health care. Next is that everything we do must perform according to the requirement of beneficence. In other words, what we do for a patient has to be done for the patient's best interests as we see them through our best training, knowledge, and skills as physicians. So we don't do things for patients because we need to do another one of these to balance the books in our office this week, or because, gee, I'm out of practice, I haven't done one of these and I'd like to do one. We do it because it's our best judgment and using all of our knowledge that it is in the best interest of the patient, beneficence. Next is non-maleficence, the flip side of beneficence. We have an obligation to never ever do anything to or for a patient that would intentionally cause that patient harm. Inevitably, situations occur in medicine where physicians will do things for patients that they genuinely, honestly believe to be in the patient's best interest, and nonetheless things will come out badly and the patient may suffer. That can occur. However, in our best judgment, the weighing the benefit to the patient versus the risk of the patient, we have an obligation to recommend the course of action that is most likely to provide benefit to the patient. And then finally, the fourth element of our obligation to patients is that of justice. Justice has many meanings on many levels. One fairly simple and superficial meaning is that justice demands that whatever treatment would be available to a patient in Wellesley or Weston should be available to a patient from Dorchester or Roxbury. That is an absolute requirement of medicine in terms of justice. However, justice also demands that a patient have access to and understanding of the range of available options in care, and that it should not be limited by the personal philosophy of the provider. So we have an obligation to make sure that in whatever situation the patient should find herself, she has the best advice about all the full range of options that are available to treat her condition under those circumstances. Furthermore, justice demands that in the middle of a severe H1N1 epidemic, if I have one last dose of H1N1 vaccine in my refrigerator and a patient comes in and requests the vaccine, but in the back of my mind, I was saving it for my last family member who I know hasn't been vaccinated. I have the obligation to give that to the patient. That's justice, okay? It's also important to remember that the relationship between a physician and a patient is inevitably asymmetrical. We will inevitably have more knowledge about medicine and ultimately about the range of options and treatments that are available to the patient than the patient could possibly possess. We have spent our whole careers studying these things, and the relationship is inevitably asymmetrical. So that if we fail to make a patient aware of a potential treatment, it's not reasonable for us to think, well, she probably knows about that and it's okay if I don't tell her, okay? That's not justice and that's not ethical, according to our obligations. Beyond those four core obligations, ethical obligations to our patients, there are sub-obligations and corollaries, if you will. We have an obligation to make sure that a patient who consents to any procedure has done so after a fully informed process so that she understands all of the potential benefits the procedure would offer and all of the potential risks that the procedure would entail. Informed consent. Healthcare providers are licensed. We are allowed to do things that other people aren't allowed to do. I can walk into an operating room, take a very sharp knife, and cut a very large hole in a woman's abdomen, okay? Other people can't do that, okay? With that responsibility comes other burdens and responsibilities that I must accept if I want to be a physician. And part of those responsibilities are to fully inform a patient and to make her aware of all of the potential treatments available to her under her circumstances and available from medicine. And finally, a healthcare professional should not put him or herself knowingly into a position likely to result in a situation of moral conflict. So, as Reverend Hehir alluded, if you know that you have a conscientious objection to launching a nuclear weapon, you shouldn't volunteer to work on a nuclear submarine that's armed with nuclear missiles, okay? That's just not a smart thing to do. And similarly, if you're a physician and you have an objection to providing, let's say, emergency contraception or abortion care services, you shouldn't volunteer for the job that's advertised in the newspaper from Planned Parenthood, okay? That's just not a good fit, okay? So we have an obligation there. However, inevitably, situations will come up that are unforeseen where a physician could be put into a position of conflict of conscience. Those happen inevitably, and as Reverend Hehir said, inevitably somebody's autonomy has to suffer, okay? Either the patient doesn't get the service that she wants, or the physician may feel that he or she has to compromise his or her conscience. Let me tell you one other anecdote that is a real story, a real situation that occurred to me very recently. I had a patient come to me who was a Jehovah's Witness. She had 4 prior babies. She had several prior cesarean sections, and she had a placenta that was invading the wall of her uterus, okay? I knew that I was going to have to remove her uterus, and I knew that that surgical procedure is associated with substantial hemorrhage. I met with the patient and her husband on several occasions. Interestingly, another twist on this is that the husband was not a Jehovah's Witness. And during our counseling session, he tried very hard to talk her out of her objection to receiving blood and transfused blood. we had a long discussion. I did not abandon my obligation to try to convince her that this was not a wise choice, that this was not a wise course for her to pursue. I told her in all honesty that I had never previously done this operation without losing 8 units of blood and requiring 8 units of transfusion, and that is roughly her total blood volume. Okay? Nonetheless, she was steadfast, and it was obvious to me that the husband was there. He was there to take care of her other 4 children and the 5th child that I was about to deliver. We made fairly extraordinary arrangements, and we were actually able to perform her operation without transfusing her. However, I went into that procedure fully aware of the possibility that my commitment to honor her decision to refuse care, in this case transfusion, might result in her not leaving that operating room alive. And if there is anything that's built into the DNA of an obstetrician, it is that you don't allow a patient to bleed to death, okay? So it was a situation where I had to adjust my expectations, my plans, my conscience to the patient's conscience, moral and ethical beliefs, and her autonomy to make decisions in her care. We were fortunate that everything worked out as well as it did. I have some other comments and thoughts, but I think maybe I'll wait and move the conversation.
Up to you. We have time. All right, thank you very much. Melissa?
Thank you so much. Make sure my mic
There you
is
go.
on there. Good evening. It's great to be here with you, and I want to just say how honored I am to be here with my co-panelist and with Eric Owens, an esteemed colleague from goes long back, and also Alan Wolf. I've appreciated his work so much through the years, and it's great to be here with him. Thank you all for coming tonight. It's proving to be a fascinating discussion, and I'm going to try to spend a little bit of time shedding a bit of light on some of the legal issues that animate this discussion. We're talking about where we respectively come from. My training as an attorney, more specifically as an attorney working on church-state issues, religious freedom issues, church-state separation issues. And so I'm going to speak a little bit about the constitutional backdrop that is behind some of these questions, then move secondarily to look at a glance at some of the specific conscience clause provisions that we have in the law presently. And then, to the extent I have time remaining, talk a little bit about the policy, political, and legal debate we're having about these issues right now, and kick in a few initial stabs at some ways in which that discussion might be improved. So let me start with the constitutional backdrop. As Bryan here mentioned, the idea of conscience has been with us from the founding of our nation, and certainly before that. It was James Madison who in 1785 wrote the Memorial and Remonstrance Against Religious Assessments, in which he said the religion of every man must be left to the conviction and conscience of every man, and it is the right of every man to exercise it as these may dictate. He went on to say, talk about the duty of man to his creator, and he described this duty as precedent, both in order of time and degree of obligation to the claims of civil society. So this idea that many Americans have, that we have certain convictions that come before our obligations, even to the civil order, has been long with us, and we've struggled with how to have the functioning civil society while also honoring these religious convictions, especially when they conflict. Both the First Amendment's religion clauses have something to say about these issues. As you know, the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And The first clause is known as the Free Exercise Clause, and it protects the rights of individuals and institutions to exercise their faith as they see fit. This provision was interpreted before 1990 to have real teeth, if you will. When there was, for example, a burden that the state placed on religious exercise, the state had to justify that burden with a compelling interest, something like health, safety, something of this nature. Or if it couldn't do that, then it had to lift that burden off the free exercise. So under this kind of standard, we actually had many religious exemptions from generally applicable laws that were mandated by the Free Exercise Clause. The government had to give an exemption to religious objectors to generally applicable laws in many instances because it didn't have a compelling interest in not recognizing such an exemption. However, in 1990, the Supreme Court decided a decision called Employment Division versus Smith, and it significantly undermined that free exercise standard that was very tough. Instead, in an opinion written by Justice Antonin Scalia, the court said that if there was a law or a governmental act or other governmental action that was neutral, meaning it didn't target religion for poor treatment, and it was generally applicable in that it applied to all people that were similarly situated, not just, a certain slice of people or only religious people or something like that, then that law was basically compliant with the Free Exercise Clause and did not need to be subjected to more scrutiny in order to pass constitutional muster. So that was a big shift. And it's important for our discussion, particularly because after 1990, the conscience clauses and the religious exemptions that we see in legislation are largely permissive accommodations. They are not mandated accommodations. In other words, the legislators who put them into laws aren't required to do so, basically, under the Free Exercise Clause, but they are permitted to do so. And so that becomes an important part of the picture, and I think perhaps could explain a little bit of why we have a more contentious debate about these issues today than we did pre-1990. We also have some other ideas that survive that are free exercise concepts, even in this weaker standard of interpretation that the Supreme Court now observes as to free exercise matters. And that is that the right of organizations to have a certain degree of religious autonomy continues to survive, although it's ill-defined in the law at present. So when Bryan Hehir was referring to the importance not only of individuals being able to exercise their faith, but organizations that are religiously affiliated being able to express their faith in certain ways and govern their activities in light of certain religious convictions, that is a right that survives in the free exercise interpretation. But it depends on what court you're before as to whether it has a lot of bite or whether it's relatively toothless in nature. Well, of course, there's another very important provision of the First Amendment called the Establishment Clause, which says, put very simply, that the government can't promote faith, it can't sponsor faith, it can't promote religion over non-religion, and it can't promote one particular faith over another particular faith. Also, importantly for our discussion tonight, the Establishment Clause guards against governmental action that would accommodate religious practices in ways that would burden the rights of others in a very significant or marked way. So a minute ago, we were talking about these permissive accommodations that are in the law. Well, especially to the extent that these are articulated as exemptions only for religious institutions and individuals, a court will look at whether those exemptions place severe burdens on other people, in the medical context, patients or others seeking access to care. And that will be a part of the analysis as to whether the exemption meets the dictates of the Establishment Clause. So again, the bottom line that I think is most relevant for our discussion tonight is that religious exemptions from neutral, generally applicable laws are not mandated by the Constitution, basically, in our understanding today, but they are constitutionally permitted as long as they meet certain standards, including certain Establishment Clause standards. And so, because we exist in this state today, we have many permissive accommodations from the legislature for religious objections to neutral, generally applicable laws. And in this area of the healthcare area, we see some that are articulated as being enjoyed only by people who have religious objections to a law, and others that are broader, as Bryan mentioned earlier, that have to do with someone who would have any moral or ethical objection to, for example, providing a particular healthcare service. Well, let me mention one other overarching legal provision that's not constitutional in nature, but it is a federal law, a federal statutory law that comes up, especially when we're talking about pharmacists and what kind of obligations are on them these days, particularly in the time at which Plan B is being offered, and that creates some controversies sometimes. And that is the federal law is Title VII of the Civil Rights Act, which applies to private employers who have 15 or more employees, and also to the government. In this context, Title VII says that the employer has a duty to reasonably accommodate an employee's religious refusal, for example, to provide particular medical services or medicines, but it only has that obligation if doing so would not cause an undue hardship for the employer. Now, undue hardship may sound like it has a lot of teeth in it, but actually courts have read that standard to be fairly minimal in nature. If something requires more than a de minimis cost for the employer, then they can say that it would cause them an undue hardship, and they can deny the accommodation that's religiously based. Well, again, because of this backdrop, we have a series of conscience clauses and religious exemptions in the healthcare arena. And the first ones emerged in the wake of the Roe versus Wade decision in the 1970s. Some courts in the wake of the Roe decision held that receipt of federal funds obligated institutions to provide abortions and sterilizations and some other, those were the main services that were at issue at that time. Congress reacted quickly in the wake of those decisions and said that the receipt of federal funding doesn't in and of itself obligate individuals or entities to provide these services if doing so would be contrary to the religious beliefs or moral convictions of the individuals or institutions. So you may be familiar with some terms like the Church Amendment. This is the idea I'm talking about was embodied in the Church Amendment that was framed in the 1970s. And since then, there have been other provisions that have echoed and expanded that kind of protection for conscientious objectors to the provision of services like abortion and sterilization. When in the recent years, in the last decade, Plan B has become something that has been offered in pharmacies, some pharmacists began to feel a dilemma similar to the physician's dilemma, or some physicians' dilemmas in the 1970s, that they felt that, in their view, providing Plan B would be participating in an abortion provision. And so they started to assert conscientious objections to that idea. And what we've seen in the wake of that is a spate of state laws on these issues. Some state laws requiring pharmacies to stock this emergency contraception without conscientious objection being recognized or dealt with. some other laws that recognize conscientious objection and do so in various ways, some more absolutist, some less absolutist. And that's an area of continuing debate both at the federal and state level. Also, in healthcare reform, we know that there was a very important debate about abortion in that context, and also about conscience. But let me just mention as well that the healthcare mandate, the mandate that every individual buy healthcare insurance, is subject to some religious exemptions. And I'll mention just one of them. One exemption says that individuals are exempted from this mandate to buy insurance if they are members of a recognized sect that has established tenets or teachings opposing acceptance of government-subsidized healthcare benefits. So this is just another point in our wealth of conscientious issues in the healthcare arena. This particular exemption is based on an exemption that was created in 1965 to exempt the old order Amish from paying Social Security self-employment tax on their farm income. So it was articulated based on that earlier exemption, but does not just apply to the Amish, but anybody that would meet that particular exemption, which is more specific than I have time to describe right here. Let me just close out these remarks by talking about moving forward. I do agree that we have significant fragmentation in our political life today, and particularly around these issues, among others. And I think you see in this debate about conscience clauses and religious exemptions, oftentimes a difficulty of one side being able to honor the other side of the equation. As my co-panelists have indicated, there are varied interests here, and they must be balanced. They must be recognized as legitimate. But in the political debate, we often see a complete unwillingness to recognize the other side of the equation. And so I think that one of the things that I hope we can do moving forward is have more discussion outside of the political arena per se, meaning outside the legislative arena is what I mean, and talking among people who have various points of view on these issues and trying to come up with some common ground principles that should govern our discussions. The first common ground principle would be the one that I just mentioned. I'm just throwing out a few here. That there are competing interests. There's the interest in recognizing and respecting the conscientious objection and the religious convictions of providers. But there is also the very important aim of protecting access to care and recognizing that an objection by one provider to providing certain services should not stand in the way of someone else being able to access lawful medical services. So we need to recognize and respect the moral autonomy and the needs of both patients and healthcare providers. I don't think we can solve all these areas, all these issues in it and tie them up in a neat little bow. I don't mean to say that at all. But I hope that we can do a few things that might help us have a more productive conversation. A couple of specific ideas here. I think the idea of disclosure has been raised a number of times. I hope that we can work toward a very consistent regime that expects disclosure from providers about the conscientious objections or religious objections that they might have and could anticipate having to certain medical procedures. That should not be something we find out down the road in a crisis, in a conflict. It should be disclosed and it should be known by people. They shouldn't have to dig for that information. It should be provided to them at the outset. I also been intrigued by an idea that I saw explained by ACOG in some of its opinions, talking about that the obligation to provide medical services rests, of course, on the physician and the employer to some extent, but perhaps more aptly even on the professional organizations that provide medical services. Can we work with information sharing through some of the professional medical organizations that might be able to provide people with information about where they can get particular services so that it avoids some of these conflicts between a particular doctor and a particular patient? Also, I think we need to recognize that there are differences between mere inconvenience in getting medical services and lack of access to medical services. We need to talk about that. If there's a pharmacy close by that could provide the service you're after, then let's meet the need that way. That would be mere inconvenience. But there's something else where there's actual lack of access, and we need to differentiate between those things. Let me tick off just a few more very quickly. I think that sometimes we confuse the idea of conscientious objection or religious objection with creating roadblocks to patient access. Conscientious objection, I think properly understood, is a particular provider saying, I need to step back from providing this service. It is not allowing that provider to create a roadblock to lawful medical services for the patient. We also need to recognize that conscientious protection in the healthcare arena does not mean that healthcare professionals may coerce, mislead, or lie to patients, or otherwise engage in proselytization, exhibiting attitudes of moral arrogance, or engaging in other abuses of power. So these are just a few ideas that I kick into the discussion as rudimentary, to be sure, and ones that won't solve all the problems, but may help us to start to have a better conversation about competing rights in this area. Thank you.
Thanks a lot, Melissa and Dr. Greene and Father Hehir. We'll try to continue this process of avoiding misinformation and dissembling by bringing all of you into the conversation. We obviously have a terrific and rich amount of ideas and concepts here that are overlaying and interrelated. So I hope that you'll feel free to bring these into conversation. So the floor is yours to begin with. Yes, please.
Make one more.
Yes, please. Pull up on it. There you go.
I was sort of hoping that someone else would tackle this, but I thought it was it's worthwhile to spend a minute or two to talk about what conscience is. What is conscience? And when I was a little kid, conscience was Jiminy Cricket standing on your shoulder, whispering in your ear as to what the right thing to do was. That sort of trivializes conscience, but it deserves a little more thought than that. There are a number of more profound thinkers than I who have given a lot of thought to the idea of what conscience is, and I thought I would just mention them briefly. One suggestion is that conscience may be, quote, an unwarranted and inappropriate intrusion of personal morality into the realm of professional conduct, and that it contributes to the diminution of the difference between our personal lives and our professional duties. The other sort of antithesis of that is that it is morally non-negotiable and beyond critique. And I would suggest that both of those represent extremes that suffer when you look at them carefully. Julian Savulescu said that the door to, quote, a value-driven medicine, unquote, is a door to a Pandora's box of idiosyncratic, potentially bigoted and discriminatory medicine. That is not conscience either. Thomas Aquinas had a much more practical notion of what conscience was, and he said that it was, quote, knowledge applied to an individual case. Another theoretician, John Mahoney, suggested that conscience has a much humbler, more pedestrian, and less exalted function than many people appear to suppose. It is simply, as Aquinas argued, the result of thinking hard, honestly and practically on a particular issue, and canvassing aid from wherever possible, rather than being an internal oracle. And this is one of the discussions that, a thread of the discussion, is conscience something that's private, deep within you, that's immutable, or is conscience something that we all possess but is modified? It's modified as we go through life, and in fairness should be modified according to the facts of the day and the patient, if you will, in front of you. Herbert McCabe said that for Aquinas, conscience is neither a faculty nor an innate moral code, but simply the judgment we may come to on a piece of our behavior in the light of various rational considerations. One of the tests, many people have said, how do you test whether someone's objection to something is truly a matter of conscience? And others have responded, well, it's a fundamental, deeply held belief. In fairness, that's not an adequate explanation either. In the news, with distressing regularity, we hear of some parents that have locked their children in a closet for 6 years and fed them only bread and water because their conscience told them that that was the way to an upright and moral life. None of us would, I think, agree that that's a legitimate claim of conscience. So just merely being convinced that whatever you think and whatever you're doing is right is not necessarily a good conscience. And then finally, there has to be some, in my opinion, some limit to the reach and realm of conscience, and that there has to be some limit to conscience claims, and especially when it comes merely to informing a patient. And some providers will claim that informing the patient of an option that they disagree with makes them in some way complicit in performing whatever the act is that they would object to. And in that regard, I'm reminded of a wonderful cartoon that I saw some years ago, which was of a courtroom scene where there was a lawyer in front of a farmer, or an obvious farmer on the witness stand. A guy was in coveralls and overalls and a plaid shirt with a straw hat. And the attorney in front of the farmer is saying, so then you admit that you grew the corn that was made into the whiskey that was consumed on the night of the fatal accident, okay? So there has to be some rational limit to responsibility and, if you will, complicity in someone's behavior. So.
We happen also to have an expert on conscience provisions next to me here. I know Father Hehir wanted to jump in on that as well.
Well, I don't know if I'm an expert, but I had a sort of undulating experience as you went through these various descriptions. With some I could live, and with some I couldn't. For myself, whenever I talk about conscience, I always talk about a capacity, a process, and then a judgment. So in that sense, that is to say, I think in the beginning, conscience, it isn't a faculty as such, although you get into complex discussions about synderesis in St. Thomas. It is not a faculty as such, although I think it is much a product of our intelligence, not only that, but it's a capacity to know the moral, it seems to me. It is a human capacity. A distinguishing characteristic of being human is the ability to know the moral, in the midst of the personal and in the midst of the social. So I would not divide those two as radically as you did in the beginning. It's a capacity. I think every now and then, happily not too often, we encounter human beings and we think maybe they don't have the capacity to know the moral at all. The example that always stays with me is that in the war in the Balkans in the early 1990s, a particularly vicious war in all its dimensions, carried out most viciously, but not only, by the Serbs. There was a Serbian major figure that was finally captured, and he had used rape as a tactic all the way through his proceedings. And in the courtroom, he was presented with these extraordinary claims of what he had done to human beings, and he seemed to have no capacity to react to it whatsoever. Now, I think every human being in principle has the capacity to know the moral, but every now and then you might get to someone who seems not to have brought that to any kind of fulfillment. Conscience, on the other hand, is a process. I think it's what often called formation of conscience, and that's where intelligence comes in, and that's where learning comes in, and that's where you draw from multiple places, and conscience can be corrected. I agree with that fully. And then finally, conscience is a judgment, it seems to me. You finally come to the point where you say, here's where I stand. I'm willing to defend what I've done. I'm willing to pay the consequences for good or for ill. The part that I particularly found difficult was your argument that it is purely personal and not to get in the way of your professional. I would argue for more connectedness and inherent integrity between, not integrity as opposed to not an integral person, but integrity of how you combine the personal, the professional, and I would say the public and the political, because it seems to me I want political figures that want to have a capacity to know the moral in the midst of the most complex political choices that we face.